there are 2 sign-in sheets out front. One is for lawyers to make sure you get your CLE credit. So if you're a lawyer, make sure you sign the lawyer's sheet. The other one is if you want to get updates from the ACLU or information about this particular issue as we move forward. We're looking at this as a multi-year issue starting now in 2016 with public education, several years worth of public education, so that people know about this problem. Most people don't even know that this problem exists in Louisiana, let alone what it would take to solve it. So after a few years of educating the public, we can then move forward with a legislative initiative, which will ultimately then have to result in a constitutional amendment, but that's years away. I also want to thank, before we go any further, I want to thank first of all the Southern University Law Center for hosting us. We obviously couldn't have done this without the gracious help of Professor Bell and Chancellor Kerr and the staff here. So, and the many sponsors, too numerous for me to recite, but all of the many groups and organizations and individuals who stepped up to co-sponsor this event, to help provide that wonderful food outside and get the word out to bring people here. So I just want everybody to take a look at that list and remember who they are, because they deserve your support. And I'm going to turn it over to the moderator, Cheryl Mercedes from WAFB, and she's going to introduce the panel.
Thank you so much, Marjorie. How are y'all doing this evening? Thank you so much for joining us here. Let's introduce you to the folks who are going to be speaking to you briefly tonight. I believe it is a format of 10 minutes each. And then we'll follow up with some questions. I'm not sure if you'll be writing them down and then we'll take them, or if I'll be walking around and taking them directly from you where you can ask them. So let me tell you a little bit first about Angela Bell here. She is Associate Professor of Legal Analysis and Writing here at Southern University Law Center. She is committed to causes involving criminal justice reform, at-risk children, prisoner reentry, and the plight of the poor. Her scholarly interests include restorative, social and racial justice, criminal justice, civil rights, and human rights issues. She has made many media appearances and participated in many local, national, and international media interviews and collaborations to discuss her scholarship and her advocacy work. Tonight, she will be discussing the history of the law with you. Let's hear it for Angela Bell. We have Will Snowden here to my left. He's a staff attorney at the Orleans Public Defenders, working on felony cases where he has seen discrimination in jury selection. In response, he created the Juror Project, which is an initiative aiming to increase the diversity of jury panels while changing and challenging people's perspective of jury duty. The Juror Project makes presentations at high schools, colleges, churches, neighborhood associations, and other community gatherings to discuss the importance of jury service, the discriminatory practices of some prosecutors, as well as people, and if they actually get on a jury, what that entails. Williams is from Milwaukee, Wisconsin, welcome here, and is a graduate of the University of Minnesota and Seton Hall Law School. There he served as president of the Black Law Students Association. Additionally, William was a Seton Hall Law Center for Social Justice scholar, taught constitutional law at a local Newark, New Jersey charter school, and was awarded the Elizabeth Ann Seton Student Servant Leader Award. Welcome. And in the center here we have Calvin Duncan. Calvin spent over 28 and a half years in prison, folks. 23 of those as a jailhouse lawyer at Angola. He is currently director of the Light Justice Project, which ensures that everyone is notified of the results of their direct appeal and that everyone is provided legal assistance through the inmate lawyers to appeal their case to the Louisiana Supreme Court. In every case involving a non-unanimous jury verdict, he makes sure that the case is appealed to the Louisiana Supreme Court and then finds a lawyer to appeal to the U.S. Supreme Court. As of today, his project has appealed at least 17 such cases to the U.S. Supreme Court and is currently monitoring at least 8 more cases to make sure they are also appealed at the U.S. Supreme Court level. Let's hear it for Calvin Duncan. We'll begin first, we believe, with Professor Bell. Yeah.
I hope I can stay through here. It's gonna be embarrassing if it doesn't work. All right, good afternoon. My role is to talk to you briefly about the historical aspects of this law. I am going to attempt to put some context to this law, why we have it, how it came about. Are you hearing me okay? Yes? Okay. Also, I have published an article on this, so this is also the end of a research project for me that I'll be sharing, and a copy of the article is outside if you'd like to have copies. The starting point for this conversation tonight will take us on a journey back in time to the slavery era. And there are two things about slavery that you have to understand in order for this conversation to make sense. The first thing that you have to understand about slavery is that it was an economic institution. We're dealing with a total of 4 million people enslaved throughout the United States during the slavery era. Specifically in Louisiana, when emancipation happened, there were a total of 300,000 slaves in the state of Louisiana. Slaves made up 46% of Louisiana's population. So at the time of slavery, this is the absolute largest financial asset in the United States economy. Slavery was worth more than any other industry in the United States at the time of its existence. The Louisiana economy was completely dependent on slavery. First point. The second point is that slavery had a lot to do with a caste system, a system of designing roles for people to play in society, where some people would have power and some people would be rendered powerless. Those are two aspects of slavery that you must understand. And now I will ask you to take a journey in time with me. And we're going to explore some specific dates and some specific events to make sense of how it is that we arrived at this particular piece of legislation. The first thing I'd like to make you aware of is that Louisiana is a civil law jurisdiction. That is very unique to Louisiana. We are unlike any other state. And in a civil law jurisdiction, legislation is sacred. Legislation is very, very important in a civil law jurisdiction. And so that is why in the year 1857, when the legislature met, they enacted a law to say that they will not allow any slaves to be emancipated in Louisiana. This was in 1857. So this was a very strong statement of legislative will that this institution is sacred and it will be guarded in the state of Louisiana. And then in the year 1860, President Abraham Lincoln is elected. And as soon as he gets in office, immediately the talks of emancipating slaves begin. Louisiana didn't like the sound of what it was hearing, and so in the year 1861, a mere 1 year after Abraham Lincoln was elected, Louisiana passed an ordinance of secession, which essentially said the state is a free and sovereign republic. We are not a part of the structure. We are separate. And so did many other southern states. They then formed the Confederacy and the Civil War began. Now I'm in the year 1863. The Civil War has been ongoing. And then we get this document that many of us hail to be very significant called the Emancipation Proclamation. And many of us think the Emancipation Proclamation did some magnificent things, and I'm here to correct that profound misunderstanding. The first thing that you must know about the Emancipation Proclamation is that it did not free all the slaves, as you may have heard. In fact, it explicitly exempted slaves down in Louisiana and many other southern states. The second thing that you must know about the Emancipation Proclamation is that it was not a humanitarian act. It was not about civil rights or concern for people's well-being. The Emancipation Proclamation was a military measure. It was a wartime measure. And I cite to you specifically the language from the document that says, by virtue of the power vested in me as Commander-in-Chief of the Army and Navy of the United States, as a fit and necessary war measure for suppressing said rebellion. And it continues, I free the slaves. Very, very important aspect of this story because it created a problem. And the problem was that emancipation had nothing to do with the interests of the slaves or the agenda of furthering civil rights in this country. It was done through an executive order, and it was forced upon the South. And the South resisted. And they resisted because they wanted to guard this very precious economic enterprise and this caste system that had been developed so successfully. So now we are in the year 1864. And because of the Emancipation Proclamation, the state of Louisiana has no choice. So we have a law that comes out in Louisiana in 1864 that says if a person is taken to trial, we can actually begin proceedings within 48 hours of you being told that you are accused of something. 48 hours. Process that. 48 hours from the time you are notified of a crime, you can be taken to trial. That happens after emancipation. Now in the year 1865, some very important things happen. The Civil War ends. That is very significant. And then there is the look of progress. There's this thing called the Freedoms Bureau, where Congress says we're going to actually help these freed slaves. We're going to help them transition from servitude to citizenship. It looks very promising. And then we get this thing called the 13th Amendment. And this is powerful because it is constitutional in nature. And so it says to people that there's no longer slavery in the United States. So hopes are high, of course, and then Lincoln is assassinated. And when Lincoln is assassinated, there's an immediate push to get all of these Confederates out of the Louisiana territories, all these military heads that were in place, get them out. Let's return Louisiana back to the institution it was. And we see immediately in the year 1865, the creation of this board of control over the penitentiaries in the state of Louisiana. This is very significant because prior to this moment in time, penitentiary was not a place where you saw a lot of African Americans. Why? Because they were dealt with on plantations. And so the population in prisons at that point were nearly all white. But you see this immediate change when this board of control takes over, and they set the parameters for what is permissible labor now for inmates. And they say things like, this is a direct quote from the transcript, prisoners shall be made to labor from sunrise to sunset throughout the entire year. Prisoners should manufacture things, brick, cotton, wool, maybe even tannery. So we see this idea of people going to prison and they work very hard and they don't get days off. And then we see a change in law all of a sudden. Very conveniently, we start to criminalize things like vagrancy, for example, in the year 1865. Vagrancy suddenly became a hard labor sentence. And the hard labor sentence would, of course, subject you to that hard work that I just described. And then you see Louisiana a year later, 1 year later, create what is called the convict leasing system. So now we can legally lease people out once they are incarcerated. So if we get them into custody with these laws like vagrancy, for example, we can make profit off of these people and, more importantly, return them back to those plantations that the 13th Amendment had just removed them from. Now in the year 1869 enters this very powerful figure that you must know. His name is Major Samuel James. Major James was a Confederate fighter, and once the war ended, he went on to his next venture. He purchased a piece of property which was a plantation at the time, and that plantation sits not far from us. It is called Angola. And Major James started the business of taking these free people who were now being basically trafficked into the criminal justice system and profiting off of the backs of these people. Major James was very powerful in the state of Louisiana. He always had control with the legislature. He was able to shape very effectively prison policy post-emancipation. And obviously he had a self-interest in what he was doing. And now we reach the year 1890, when we see these Jim Crow laws start, and then we see the poll tax start, and we see some of the progress starting to be taken back. And now I'm at the year 1898, which is the very critical piece of this conversation, the year 1898. Because in the year 1898, there was a constitutional convention. And there were three very critical things that the state of Louisiana needed to resolve at that convention. The first was suffrage. It was the conversation of voting for these newly freed slaves who had never voted. It was criminal justice reform, because we didn't have to deal with criminal justice as a state. It was dealt with privately. And then the last thing was education, because now these newly freed people have to go to school. So these were three major issues, and the infrastructure for our entire government was laid at this 1898 convention. And so that convention went on for 94 days. That convention, I would ask that you walk with me in the room. And the first thing you see on this journey into the room at that 1898 convention is women who were segregated. You see ladies sitting in the gallery. That was by order of the state. They had to sit 50 feet on the side of the balcony. And now I want you to, in your mind's eye, pretend hearing these comments that I will present to you off the record from the 1898 convention, and I am nearly concluding. The first I quote to you, this was said on the record in 1898. The most revolting scheme of the federal government, the most irritating and dangerous, was the proposition for mixed schools, the co-education of the races, the late masters and the late slaves, Caucasian and African, in the same schools with the same teachers. It continues. This is a proposition that is so alarming, so pregnant with untold evil. Off the record. Next quote. We need a radical change in the judicial system. We need a system that is better adapted to the peculiar conditions of our state. Next quote. They discussed the report on convict leasing, and they decided that this was working well and that they should formally endorse it. There was a vote, 104 votes, not one opposition to the idea of convict leasing. And then they discussed lynching. And somebody suggested that maybe, just maybe, they might consider legislation. And then they said, no, we'll indefinitely postpone any talks of lynching legislation. They quickly agreed to a poll tax. They quickly agreed that the Confederate soldiers were entitled to a pension, but they were silent as to any discussion of the slaves being compensated in any way. And then, Article 116. Article 116 was approved and continued from its 1880 enactment, and Article 16 said that it is permitted to have non-unanimous juries, 9 of 12. It is permissible. And then I end with two final comments. This is on the last day of that 94-day convention as they reflected on what it is that they accomplished. The first comment is from Thomas Sims, who, by the way, was the chairman of the Judiciary Committee. And Mr. Sims says in his reflections, the work we have done should be crowned as worthy. I have no apologies to make, no regrets, Nothing to change, nothing to recall. In all states, those in power seek to maintain it. Our mission was to establish the supremacy of the white race in the state of Louisiana to the extent that it could be done legally and constitutionally. And the concluding remarks came from a member of the bar by the name of President Husinik. And I quote as I close, "I say to you that we can appeal to the conscience of the nation, both judicial and legislative. And I don't believe that they will take responsibility of striking down the system which we have reared in order to protect the purity of the ballot and to perpetuate the supremacy of the Anglo-Saxon race in Louisiana." And there, the non-unanimous jury law was legitimized by the Louisiana state officials.
Before we introduce William Snowden and begin speaking about his project, Southern would like to encourage everyone, if you're on Twitter, how many people here are on Twitter? Yeah, raise them high. To use the hashtag, if you aren't going to tweet, they're encouraging that you do as our speakers are talking. The hashtag shame on LA is in Louisiana, so hashtag shame on LA. And also hashtag just trials for the number 4 LA. So hashtag just trials, the number 4 LA. All right, you can go ahead, Mr. Snowden.
I looked around the courtroom. The judge was white. The jury was white. The prosecutor was white. And even though I was innocent, I knew I had no chance. Those are the words of an exonerated death row prison inmate, somebody charged and sentenced to death. And within those words, he highlights a problem that's going on in our criminal justice system. There's lack of diversity across the board. But more importantly, there's lack of diversity in our juries. And so, how does this problem present itself? How many of us think that our criminal justice system is 100% fair? How many of us know of an opportunity on how we can bring fairness to this criminal justice system? Jury duty is something that we do not talk about. And I'm here today to briefly talk to you about how serving as a juror is a very unique way to be involved in the criminal justice system. And it's a way that you can bring fairness to a very unfair system that's not going to cost you a dime. You don't have to be a governor, you don't have to be a legislator, you don't have to be a president. When you get that jury summons in the mail from this day forward, you will be excited about that opportunity to serve your community. When we think about how the lack of diversity creates itself in juries, we need to think about how people are being removed. And that's a problem that's going around this country, is strategic removal of minorities from the jury panel. And just very briefly, there's something called the voir dire process, which is the opportunity for defense attorneys and prosecutors to question potential jurors to see if they would be a good fit for that particular trial. And within that process, prosecutors can remove people for either a cause strike or a peremptory strike, and defense attorneys can remove people for a legal cause or for a peremptory strike. But when that happens with strategic removal of black folks, a defense attorney can raise what's called a Batson challenge. And you probably all may be familiar with the Batson challenge. And the way that it works is a defense attorney representing a client will say, Judge, I think the prosecutor is removing all the minorities, strategically moving minorities from the jury panel. I'm going to exercise a Batson challenge. That's step 1. Step 2, the prosecutor has to give a race-neutral reason explaining why they removed that potential juror. Step 3 is the judge has to play referee in deciding whether or not that reason was in fact race-neutral. I'm going to read to you 3 quotes of race-neutral reasons that were offered by a prosecutor. And they were all deemed to be race-neutral by the judge. The first is from a case, State versus Crawford, here in Louisiana. Defense attorney raises a Batson challenge. Prosecutor says, Judge, I'm not trying to remove this black person because he's black. I'm removing this juror because he looked like a drug dealer. Another challenge raised. Judge, I'm not removing this black person because they're black. I'm removing him because he shucked and jived on his way to the witness box. You saw him. Race neutral reason. The third, Judge, I removed this person because he was too stupid to live, much less be on a jury. These are the race neutral reasons that have been offered, and if you don't believe me, you can look up the cases yourself. State versus Crawford, State versus Tomlin. These are reasons that have been offered that were actually sustained by a judge by saying they are race neutral, but I think we all can agree that there's a racial undercurrent message in those words. And unfortunately, there have been prosecutors who have received training on how to mask that racism, how to mask that discrimination, and they know what they're doing. And so what is it that we can do as citizens to actually get on a jury? Because that's what we're needed. There's always legislation about jury violations after a case has happened, but today is the day where we change that. And we target it from the front. The lack of diversity is not just on the prosecutors. Right? So there are actions of individuals who will come to jury when I'm doing a trial, and they'll say, you know, I can't vote to convict this person because they only had, 2 crack rocks or a few pills. And I just don't vote guilty to that type of individual. And there may be people in this room who think that people who are drug addicts don't belong in prison. They may belong in a substance abuse facility for receiving treatment. But the answer isn't to vocalize by saying, I can't convict this person. The answer, if you don't think that person should be convicted of a drug offense, is to get on a jury and vote not guilty. Now, that might not be a popular thing to hear. I'm standing in front of you and saying, listen, the person may be factually guilty, but you have within your right as a jury to vote not guilty. Too often, prosecutors want you to think that trials are a task-oriented process. They want you to think that 1 + 1 + 1 = 3, and they'll get up in front of you and say, I have to prove 3 things. First, that this person was trespassing. Second, that when he was lawfully arrested, he had heroin in his pocket. And third, when we tested that heroin, it was positive. And members of the jury, after you hear me prove those 3 elements, you must vote guilty. That simply is not true. There's something we don't talk about in our society about jury nullification, right? One of the very first trials I had as a public defender, my client was charged with having a syringe of heroin. If we were to go to trial, and if we were to lose, he would have been sentenced to life in prison. 1 needle, 1 syringe, simple possession, not possession with intent to distribute, not actual distribution, but simply having that needle in his pocket. The reason why he was facing life in prison was because he had been convicted twice before of possession of heroin. And one of the reasons Louisiana is a prison capital of the world is because we have a terrible 3 strikes law. It does not differentiate between violent and non-violent offenders. It allows for drug addicts to be sentenced to prison for life very, very easily. And so what is it that you can do? You serve on a jury. And I talked to you about some of the reasons why we have lack of diversity. We often get people who may know individuals who have drug addiction or drug problem. And they know how their family members or loved ones or friends have been convicted and sent to prison for possession of 2 crack rocks or possession of some pills they didn't have a prescription for. And so when they get brought into that courtroom and they're sitting as a potential juror member, they'll say, I want to be part of this process. I can't vote guilty knowing that this person only had a needle of heroin, a syringe of heroin, a couple crack rocks, a couple pills. That is not the answer. Don't remove yourself from that process. Right? We need more diversity, not just diversity in color, but diversity as thought. At the end of the day, we need to figure out how we as a community can empower the people that are being affected by this criminal justice system. Well, how does the 10 to 2 non-unanimous jury play a role? Well, if you have a pen and a paper, you need to write down this website. It's called blackstrikes.com. Blackstrikes.com. Over the last 10 years, they have analyzed the jury trials that have taken place in Caddo Parish, and you specifically can go to the website, you can click on a prosecutor, and you can spin the wheel and it'll tell you your likelihood of getting on the jury if you're black or white. But what's more important is they have some very, very powerful information. They show you the influence that diversity can have on a jury trial. We all know that 10 to 2, if 10 people vote guilty, 2 people vote not guilty, that person's still going to prison. And so when there are two, say, and the studies show when there were 2 African Americans on a jury, over the last 10 years, when there was not a majority of African Americans on the jury, there were 0 acquittals. The study then shows when you increase the number of African Americans on the jury to 3 or more, the acquittal rate increased by 12%. And then when there were 5 or more African Americans on the jury, the acquittal rate increased to 19%. So what does that tell you? More diversity equals more acquittals. But I'm not telling you that once black people get on a jury, they're automatically voting not guilty. What I'm telling you is the tremendous value of having diversity on a jury panel. The studies show that you're going to have longer deliberations. The studies show that people are going to challenge each other more. And at the end of the day, more diversity equals more fairness, and that's what we desperately need. In Jefferson Parish, the studies show that there practically is no effective representation of African Americans on juries because of the 10 to 2 non-unanimous jury verdict. We know why they're trying to make it easy to lock black folks up. And now we need to do something about it. So I told you about one reason we lack diversity is because people get on there and they say, I can't vote guilty because somebody had possession of crack cocaine. The second reason is more so prosecutors strategically removing black folks and minorities from juries because they think that their chances of winning will increase with a less diverse jury, and the studies show that that's actually true. And the third is the individual who gets that summons for jury duty in the mail and says, oh man, I got jury duty. How many of us, maybe that may be yourselves, how many of us know somebody who loathes jury duty? Or who's ever said, how do I get out of jury duty? Well, that stops today. When we think about what it is that we can do as average citizens and members of the community, people who aren't involved in government, don't pass the laws, don't write the laws. When you get that opportunity to serve on a jury, I don't want to hear about how inconvenient it is for you. I don't want to hear about how the Wi-Fi in the jury room isn't working. I don't want to hear about how you wish you were somewhere else. Imagine if it were you or a loved one on trial, and they had a room full of jurors, didn't want to be there. Your inconvenience for that week could literally save my client life in prison. When the system is set up to make it easy to convict people 10 to 2, we need more than just 2 people on the jury to have a progressive mind, to have a mindset of trying to change the system. The problem across the country, and very much so here in Louisiana, is that there's a lack of diversity in our juries. Again, it's not just diversity of color, it's diversity of thought, it's diversity of socioeconomic background. With a 10 to 2 system, it makes it very, very hard for us to bring fairness when we go to trial. At the end of the day, if you're not doing something, you're doing nothing. But after today, I know that you all will do something when you get that jury summons or somebody tries to tell you they don't want to be on a jury. Because you know the power that we all have, the power that we all hold, can literally save someone's life. Thank you.
Next we'll have Mr. Calvin Duncan. Remember to continue tweeting, folks. How many people are tweeting in here right now? Good job. Anyone else need the hashtag? We're good? Yes. There are 2 of them. Hashtag shame on LA and hashtag just trials, the number 4, LA. Thank you. All right, Mr. Duncan, go ahead.
My name is Calvin Duncan, and I spent 28 and a half years in prison. While in prison, I was what they call a jailhouse lawyer. And in a lot of cases that I was had to help guys in prison, me and a bunch of other jailhouse lawyers at Angola, we would notice that the jury verdict was almost always 10-2. And we used to always wonder, how does this continue? How is it that this laws continue to exist? Despite the fact that we would research laws that's on cases by the United States Supreme Court that says that whatever the Bill of Rights says, the states must comply with it. But then in 1972, a Louisiana case went to the United States Supreme Court. The United States Supreme Court said, well, the Sixth Amendment right to jury trial to have a unanimous jury verdict doesn't apply under the due process clause. So we used to always wonder, why is nobody challenging this law? Why is the lawyers not raising these issues? Well, one of the reasons why this issue wasn't raised and why it wasn't challenged was because a lot of guys that have, all of the guys that have 10-2 verdicts isn't entitled to a lawyer after their direct appeals. But in my case, I was capitally charged. I was charged with first-degree murder. In a first-degree murder case, the prosecutor is seeking the death penalty, and our law says that in order for the jury to convict a person and sentence him to death and have him executed, the jury verdict has to be unanimous. But in every other case, it could be 10-2. After a person's appeal has been affirmed on direct appeal, he's on his own. The only help that he can actually get in prison is a jailhouse lawyer like myself and some of the other guys. So after 1972, it seemed like lawyers just stopped litigating that issue. Stopped arguing that the Sixth Amendment still required that the state of Louisiana comply with other states in this country and also the federal government. It just stopped being litigated. And then at some point it started to be litigated all over again, with the same argument that the Sixth Amendment is obligatory upon the states, and in all cases the jury verdict has to be unanimous. I'm going to back up for a few minutes. In 1972, cases that was tried in Louisiana, the reasonable doubt instruction, in New Orleans specifically, was wrong. Lawyers was arguing the fact that if you give this reasonable doubt instruction the way y'all are giving it, you're going to guarantee that people get convicted, and then it wouldn't even have a jury verdict. And that issue was litigated and litigated and litigated, despite the fact that the Louisiana Supreme Court has said that there's nothing wrong with that instruction. But then a guy in 1990, in 1989, he was sentenced to death. His name is Tommy Cage. In his case with the United States Supreme Court, and his argument was the identical argument that the lawyers was making in the 70s, that the reasonable doubt instruction is wrong. It violates due process. And because this guy was sentenced to death, he was afforded a lawyer, and the United States Supreme Court heard his case and agreed, and said that the reasonable doubt instruction given in New Orleans is unconstitutional. Regarding the non-unanimous jury verdict, that issue stopped being litigated in 1972 after the United States Supreme Court said it was okay. But then they started up litigating it, raising these claims again under the same argument that it violates due process. But then in 2013, we got the evidence. By that time I was out of prison. I got out of prison in 2011. In 2013, the case went before the Fourth Circuit and said, look, we're not arguing just under the 14th Amendment, the right to have a jury verdict. We argued that, look, we got evidence that says that when they introduced the law, the non-unanimous jury verdict, it was because of racial reason. It was to make sure that black votes did not count in the criminal district court. And we have the evidence now. However, the Fourth Circuit said, look, argument sounds good, but it wasn't preserved. There was no evidentiary hearing. And since then, since 2013, what I have done, I monitor all of the people direct appeals. If a person is not sentenced to death, like I said earlier, he's not entitled to a lawyer according to our law, so he has to rely on the inmate lawyer. However, people direct appeals was being affirmed, and it wasn't notified that their case was being affirmed, and therefore they were missing their deadline and going to the next court. So what I do under the light of justice, as a program director, I monitor all of the direct appeal cases. And once one of the Court of Appeals rendered a decision, I immediately notify the inmate lawyers at the Louisiana State Penitentiary, at Hunt. Those are the institutions that are actually working closely with the inmate lawyers. And I said, look, this guy appeal was just affirmed. Help him appeal his case to the Louisiana Supreme Court. In those cases where the non-unanimous jury verdict issues was litigated on direct appeal, I notified the individual. I said, look, if you intend to pursue your case to the Louisiana Supreme Court, and once it's affirmed, because there's no doubt the Supreme Court was one word denial guy, because they constantly saying that the issue has already been litigated. Once the Louisiana Supreme Court has denied your case, if you would allow me, I would find you a pro bono lawyer to take your case to the United States Supreme Court. So far, since we have been doing this since 2013, we have taken 17 cases to the United States Supreme Court, and I have successfully been able to do that with the hard work of the inmate counsel, inmate lawyers, that ain't over. Of those 17, United States Supreme Court denied 6 of them. One is still pending. 2 of those cases presented to the United States Supreme Court had to proceed to the United States Supreme Court without a lawyer. One of those cases is an individual sentenced to life for drugs. As a third offender, he's serving life in prison with a non-unanimous jury verdict. At the moment, it's 8 cases that's pending in the Louisiana Supreme Court, and once Supreme Court stamp it, I would hope that they would eventually look at one of the cases. But if the Louisiana Supreme Court doesn't, we will litigate those 8 cases to the United States Supreme Court with the question, look at Louisiana laws, look at Louisiana non-unanimous jury verdict law. It was racially motivated, and therefore it violates the equal protection clause of the United States Constitution, 14th Amendment. We're going to continue to litigate this issue to the United States Supreme Court until the United States Supreme Court says we are correct. What I would like, and what I would hope, is that trial lawyers file the issue, litigate the issue, raise the issue, say, look, we have the evidence now. The evidence, we didn't have it in 2012, but we have it now. It's proof that when they introduced this law, it got it passed, it was racially motivated to make sure that black folks did not count. And once the trial lawyers litigate this issue at the trial court, then the lawyers, the appeal lawyers, I would hope that the appeal lawyers raise this issue before to the Court of Appeals. Why is that important? Because this issue would never get to the United States Supreme Court if the lawyers never raise it. If the appeal lawyers never raise this issue has been able to exist all of these years because for several reasons. One, in 1972, the Supreme Court said that it was okay, and we just stopped. But like in the reasonable doubt instructions, the lawyers did not stop. The lawyers continue to litigate this issue. And I would hope that if there's lawyers in the audience, law students, definitely law students in our audience, when you become lawyers, if this issue is not corrected now, when you become a lawyer, raise the issue. Tell the court that we have the evidence. We've been having evidence since 2013, at least when it was being presented to the court, that it was racially motivated. And I'm gonna end there, and I just hope that you all that's on courts, lawyers, that y'all will encourage the lawyers to raise this issue. This is an important issue. There are several guys in the Louisiana State Penitentiary serving life imprisonment for drug offenses. One of the guys that had to proceed pro se before the United States Supreme Court, this guy had 2 previous drug cases, and he was in prison when he was on trial for it was a drug case. His predicate conviction has always been drug. Yet this guy going to spend the rest of his life in prison if God doesn't intervene because he has a drug problem. And it's all because of the 10-2 verdict. If he was tried in the federal court, he probably would be convicted because in any other state, there's only 2 states that allow this kind of activity to take place. It's Louisiana and Oregon. And I often tell people I know Oregon wasn't intended to talk to black people, because when I was in Oregon jail, I was the only black person in that jail. When they did bring a black guy in that jail, it's like, whoa. And they put him in the same cell with me. So I don't know what, I'm told that the Oregon non-unanimous jury verdict was against Jewish people. But I definitely know what it was for Louisiana, because I have read it myself. It's documented, as Professor Angie Bell has outlined. It was to make sure that black folks didn't. And why is this so important? And I pray that nobody in this room ever go to trial. You have to think about it. What if any of us in this room is arrested for smoking marijuana? It is our 3rd offense. And we face a life imprisonment, and how easy it is for a prosecutor to convince 2 people. So just put yourself in those shoes, and I take the attitude that it won't happen.
Which is okay, because we're all very interesting. We're going to extend the question session until 7:30, because I know you all have wonderful questions ready to go for our speakers, correct? Okay. Who would like to go first? Raise your hands. I'll come on over to you with the microphone, and you can tell me who you are and who you're here with, whether you're a student or a lawyer, etc. Yes, sir. Would you like to stand up?
Well,
you're on the spot. We've got you now. Okay, what's your name, sir?
my name is Percy McCraney, 79 graduate of Southern University Law School. Out of Caddo Parish. And I now have a case pending on this issue before the Louisiana Supreme Court. The defendant was convicted on a 10-2 verdict of aggravated rape, but he's now been sentenced to life without probation or parole, but there was no physical evidence whatsoever. The only testimony was that of the victim. So they went to the Court of Appeals, they roughshod at the issue, but my research revealed that anytime that there's conviction based solely on the victim, it's been by unanimous verdict in Louisiana. So it's been pending. My writ to the Supreme Court has been pending since February. And I wanted to know if there's anything that I can do besides patiently wait and quietly endure.
Thank you, sir. Is your question to anyone specifically? Who would like to answer that question?
I'll say this. So far, the courts have been very predictable, Louisiana courts, in how they respond to these type of claims. And it's almost like a formula that the minute you say the word non-unanimous, they will then respond with Apodaca and say, we can't help you. And so I'm not discouraging it. I think what you're doing is necessary to preserve the claim. But I think we're at a moment in time because so many lawyers have done what you have done, which is gone to the courts and disclosed to the courts that this is violating a number, not just the Sixth Amendment, but a number of constitutional protections. It is time now that we hold the power that we have as civilians. We are in a civil law jurisdiction, and I am not suggesting that we ignore the courts. I am only suggesting that we realize that the legislature needs to now be held to task, because this is a stroke of a pen. This is a stroke of a pen. No appeal is needed. This is somebody understanding the harm, not just to defendants, because we have made a mistake when we think this is about defendants. This is really a public relations nightmare, because if the world knew that we did this to folks in Louisiana, businesses should never come here, because what we're communicating to people is that if you bring your folks here, you don't get the constitutional protections that you get in the other states. So why would you do that to your own citizens? This is not just an issue about penitentiary defendants, but this is about the free people, because if the jury gets the wrong person, we're not safe. So we really need to bring this to the legislature. This is a civilian state. I remind you, certainly keep doing what you're doing. That's necessary. But I don't think we're going to get any relief through any Louisiana court, because they have made it clear that they're going to pretend that Apodaca governs this issue, and I firmly believe it does not. Any other thoughts?
Just additionally, whenever I go to trial, I always file a motion in limine asking the judge to declare the 10-2 non-unanimous verdict unconstitutional. And it's kind of become a laughing stock with some judges. They go, oh, you're filing this again, Mr. Stone. And so we still file it because it's still wrong. And every time we file, we preserve the issue, like Mr. Duncan is saying, we need to be advocating for this on the trial level as well to make it an issue. They will continue to deny our motion, but we still have to note our objection to the denial of that motion so that we can preserve it on appeal, because we need to be attacking it on every single front possible.
All right, thank you so much. Another question here. Your name, sir?
My name is Gary Wainwright. I'm a 1989 graduate of the Southern Law Center. And right now I'm working on a 10-2 case for post-trial, pre-sentencing. I filed a very particularized motion to quash before trial. And I've actually gotten the state to stipulate to the book by Professor Amelio, the 10-2, Jim Crow's Last Stand, the 10-2 verdict in Louisiana. I've had them stipulate to that, and it's an exhibit in my post-trial memorandum.
That's incredible.
And so what I was saying, and I came up here because right now I have 5 guys doing life. I've never lost a murder trial on a unanimous verdict in my 28-year career. And off the top of my head, I've got 5 guys doing life on non-unanimous jury verdicts, and every one of them had a motion to quash beforehand. But Professor, there was something in your presentation which I think is very interesting, and that's on page 596, when you said, they continued, quote, efficiency should be the first and primary consideration. Economy should be secondary. And here I hold in my hand the response of the state of Louisiana to my motion to quash, and they quote the Louisiana Supreme Court. Well, actually, State versus Hankton, Fourth Circuit, writ denied, and a whole bunch of stuff. A quote, even if racial bias was the original motive behind the less than unanimous jury verdict's introduction in 1898, the motive in 1973 was clearly efficiency. That's precisely the exact same words they used in the beginning, was efficiency. And so, I intend to meld that into my presentation. But it's important to me that we continue to work on this issue. It's a horrendous vestige of our slave trading capital of the world past. And I want to just say something about jury duty. You can be a volunteer juror. You don't have to wait to get that summons. Go in law school. You're here in Baton Rouge. If you're registered to vote in Baton Rouge, go down to the courthouse and volunteer to be a juror. Get some friends. Go volunteer to be a juror. You'll have a great experience. And so I'm very glad we're having this. And I just hope that at some point, and I don't believe this is going to be a legislative solution. And I appreciate Marjorie saying we're going to go on a 10-year crusade to change this. 5-year crusade. It's not going to happen. In case you haven't noticed, I have. Louisiana is still the same racist shit hellhole it ever was.
Do you mind if I quickly respond just for the benefit of the students who are in the audience? But one of the comments that he's making is this. Often the courts will say that in 1974, when the Constitution changed, the record from that discussion did not have any of this racial inflammatory language. The language they used in 73 to debate this non-unanimous jury issue was all about making us have a very efficient system. And so many courts will say that that somehow sanitized this, because in 74, they didn't talk about race, and so it's not a race issue anymore. And my immediate reaction to that is, if I could take whatever judge says that and slap some shackles on them and tell them you are free. Because you're free, the shackles don't mean anything. Do you see my point? You don't sanitize racism because time passes. Very important argument that they've offered up, and I just wanted you to realize that that is one of the arguments from the other side, that this is not anymore a race issue. It has now been sanitized.
I just have one question. Where did Louisiana get the 2 from? The other case, the other state is 11-1.
Oregon? Yeah, Oregon is 11-1. Oregon is slightly different. Oregon's system came about in 1933. And in 1933, Oregon took their constitutional amendment to the voters, and they disclosed some of their reasons to the voters as to why they thought they should go from a unanimous system, which is what they had, to this non-unanimous system. And they said that they did this because there were a lot of immigrants coming into Oregon, and they started to have a lot of mob-related crime. And so they felt the mob was influencing their jury system, and so they disclosed to the voters that this would stop any influence that the mob was having in persuading 1 or 2 jurors to hold out. And so that's how the difference history and the different numerical composition happens. Also, quickly, in Louisiana, when this was debated in the 1800s, they had actual records from the Register of Voters. And so they were able to determine how many of these newly freed slaves can now vote. And that was a large part of how they calculated how many they would need to eliminate. And that's how we got the 2.
Thank you so much, Dr. Bell. Next question.
Yeah, my name's David LeBlanc. I'm a 2L here at Southern University Law Center. My question is whether, in light of Miller versus Alabama, now that life without parole is essentially capital punishment for juveniles, do you think that a good start would be to push for unanimous jury votes required for the conviction for life without parole of a juvenile? And perhaps in the ACLU's litigation strategy, or just in our push for unanimous jury for all, I think, my opinion is that perhaps for juveniles would be a good start in light of the jurisprudence that's been handed down recently.
Thank you.
People are asking me for autographs now.
I just want to say something. Excuse me, I'm Gary Wainwright here. When I was researching my reply brief to the state, I think I've discovered something that's gotten washed away with the Apodaca whitewash. Okay? In Oregon, you cannot receive natural life on a non-unanimous jury verdict. You can only receive 30 years without parole. Well, in Louisiana, 30 years without parole for a black man, some people consider that a gift. But in Oregon, 30 years without parole is the maximum sentence you can receive on a non-unanimous jury verdict. To give you natural life, it must be unanimous. So we stand, did y'all know that? We stand alone. We stand alone in this country. This is the only jurisdiction in America where you can get natural life on a non-unanimous verdict.